Hello, I am Dr. A. Arunashri Lakshmi, Associate Professor, National Law University of Odisha, Cuttack. Now, the module which I am going to deal with now is titled as Legal Systems, a Comparison. Now, the objective behind understanding the legal systems in the subject of jurisprudence being, jurisprudence basically deals with a few questions, that is, what is law, who made the law, how is law made, and why is law made, and it goes into the deeper aspects of the concepts of law, the sources of law, and the schools of law. As you have been already aware of, what is jurisprudence? Basically, it is understood as the science. It is a science of law. Right from the times of Alpine, we have been understanding the concept of jurisprudence as the science of law, as it has been stated by Austin as the science of positive law. Holland has defined it as a formal science of positive law, and Salmon has defined jurisprudence as the science of civil law. So, the science of civil law, when we talk in terms of it, it is going to be confined to a particular given legal system, where it is going to have an impact of the analytical, the historical, the sociological, the philosophical, and the ethical types of jurisprudence existing in a given legal system. But then why these legal systems we have to understand? So, by going into this particular module, you are going to be exposed to the larger world where different legal systems are going to exist. All the nations which follow the basic legal systems and a comparison of the same has to be also a part of the knowledge of jurisprudence. So, with this intent, this particular concept focuses on the legal systems, a comparison. Now, what is a legal system? Now, briefly to understand it, a legal system may be defined as the legal rules and the institutions of a given country. Now, for example, it may be an Indian legal system, the Soviet legal system, the common law system. It can be any legal system which may be defined as the legal rules and the institutions of a given country. Now, going to the next part of it, why a comparative legal system? Legal system, why it has to be compared? The reason is, it is the comparative legal system is the juristic philosophy and techniques shared by a number of nations with broadly similar legal systems. Now, why understand this legal system in the present scenario? Because the concept of one world or the global village in the era of globalization, today we hear only this word right from 1990, 80 to 90 onwards. Because of the globalization, it requires understanding of laws of different nations of the world which help in the development of having an effective legal system. So, in this context, we need to understand the legal system from a broader perspective as to what are the major legal families that are in existence in the world. Now, what are the aims and objectives? Now, suppose if we are going into the subject, by understanding different legal systems, what is it that we are going to gain? The main aim and objective is to bring uniformity in the legal system. Because of the globalization, it brings uniformity in the legal system. And when we make a study of different legal systems, we will have an international understanding. And thirdly, by having an international understanding, we will be having a better understanding and knowledge of the domestic or the national laws that are in existence. Now, what are the changes that are required? What are the reforms that are required? By having an international understanding of understanding different legal systems that are in existence, at the national level, we will be able to promote better reforms in the given legal system. As Samand has stated, jurisprudence deals with the science of the civil law, that is the law of the land. Therefore, when we venture to understand, roughly speaking, there are around 42 legal systems in the world, and out of which these only 3 are considered as important legal systems, because these legal systems have a different tradition peculiar to the system that is existing, and that legal tradition has bearing on different nations around the globe. Now, therefore, as we have already seen, by understanding the legal systems, we will be able to, as an academic discipline, it is essential for a deeper understanding, or as to make certain reforms in it, it is necessary. And thirdly, it is also essential to assimilate and bring some kind of harmonization of law in the era of globalization. So, as we see now, out of these 42 legal systems in the world that are existing, the main important systems are considered as the civil law system, the common law system, and the socialist law system. However, when it comes to the socialist law system, because of drastic changes that have taken in the socialist legal systems, it came to be recognized that only these 2, civil law system and the common law system, are the governing systems considered as the major legal families, or they are considered as the parent legal families. Now, as I said, every legal system has a style of its own, which is called as a juristic style. Now, the juristic style of a given legal system is going to include certain factors which are going to focus what are peculiar to it. Now, you may take a US model, or you may take the England, or you may take an Indian legal system, or any other system. When we take, each legal system has a peculiar juristic style, and what are the factors that are to be ascertained of regarding this particular juristic style. The number one we talk about is about the historical background and development. So, a legal system, every system has a legal background. Now, suppose you take India, it has a background of a philosophical background, that is, it has the Vedic philosophy behind it, and it has the customs that have evolved, and it has a historical background and development in understanding the juristic style. Similarly, any other country has, every country has a historical background and development. This is the first factor to determine the legal system. Now, the second part is what is the characteristic mode of thought it has, what is the approach of the principles of law that are in existing, and thirdly, its distinct institutions. Now, what are the distinct institutions? The setup of the courts that they have, the institutions through which they used to get the justice delivery, and how they have operated is peculiar to a given legal system. And fourth, the sources of law. The source of law for one country may be different from the other country. Therefore, sources of law also form an important factor in ascertaining the juristic style of a legal system. And lastly, the ideology of a legal system. The ideology is dependent because, now say for example, you take the socialist legal system, it has the economic content. Some countries have the political ideology. Some countries have the religious ideology. So, all these 5 taken together are going to determine as to what is the style, juristic style that is in existence to understand a legal system. Now, in every legal system, as I have earlier stated, it has a legal tradition and a legal culture. Now, what is this legal tradition? Every legal system has a legal tradition, and it comprises of that tradition which represent the heritage of that particular jurisdiction. And legal culture is the ideas, the values, expectations, the attitude towards law and the legal institutions which public holds good. So, any legal system consists of the legal tradition. So, in the context, as we have identified the 2 major legal systems comprising of the civil law system and the common law system, we can also understand them in the perspective of civil law tradition and common law tradition. So, it is this tradition that is going to have a bearing on different countries. Now, coming to the first part of the legal system, that is the civil law system. Now, the civil law system refers to the entire system of law which applies to most of the Western European countries like Latin America, Africa, Indonesia, Japan, etc. And this civil law is derived from the ancient Roman law and is derived and originated in Europe on the basis of Roman jus civile. Now, the word jus civile is the private law that is applicable to the citizens and between citizens within the boundaries of a state in a domestic context. So, at this juncture, I think we also need to focus upon the classification of the Roman law into jus naturale, jus gentium and jus civile. Now, the jus naturale is the law that is dictated by reason in Roman law in Rome. Jus gentium is the law that is applicable to the foreigners, and jus civile, as we have seen, is the private law that was applicable to the citizens and between citizens within the boundaries of a state in a domestic context. And we have to remember, Roman law was the earliest law and it has passed through 2 phases. One is the period of compilation of the Emperor Justinian. The second was the revival of the Roman law, where Justinian's works were studied by the Italian universities in 18th century. That is why we have to acknowledge the Roman law, because even when we start studying about the jurisprudence, it is the definition given by the Alpine, where he for the first time said the study of law on a scientific basis. He said jurisprudence is the science of the knowledge of things human and divine, the science of just and unjust. Therefore, Roman law, which has a maximum influence, is on the France and the Germany. Therefore, when we talk about civil law system, it is the French law and the German law that comes to the mind. So, the civil law comprises of the French law and the German law. Now, what are the distinguishing features of the civil law system? Now, here we find one, unlike the common law system, civil law system based on codification. They were the ones who codified law then itself given in a particular form as a fixed principle of law. If we remember the 12 tables of Rome we refer to, which consists of the customary law of the Romans, which is codified, and subsequently the institutes, which was a first systematic collection made by Gaius, and the Justinian Code, where we refer to as the Corpus Juris. Now, the Justinian Code, he was the person who made an attempt to compile all the law into code, and this consisted of the 4 divisions, which included the institutions, the digest, the code, the novels. And also we hear about the French Napoleon Civil Code, the German Civil Code. So, as what we understand is, codification is a peculiar feature and a distinguishing feature of the civil law system. And another point we have to remember is, in the civil law system, there was always a clear division between private law and public law. Now, the hierarchy of the courts that have been constituted have exclusively been dealing with the private law of the people, and the division is always marked very clearly. And the next feature we find is, justice is administered by these courts but through the laws that are enacted by the parliament. So, we need to remember that they have given much importance to the legislation part of it, and for them the constitution is supreme. And when it comes to the judicial decisions, whatever the decisions that have been delivered by the courts occupied only as a secondary source of law. And another distinct feature we find in the civil law system is, it followed inquisitorial system, which will be dealing with subsequently at the end of it, know about how the justice system under the common law and civil law is going to deal with. However, the civil law system follows the inquisitorial system. Now, this being the background, as I have said, the French and the German law have derived all their source and force from the Roman law. So, great impact of the Roman law is there on the French law, and in the French civil code there was always a separation of powers. The categorization of the laws was very clear. There is clarity over the private law, public law, administrative law, criminal law. So, separate categories were in existence. Now, on the other hand, the second major legal family or the parent legal family we talk about is the common law system, and the common law system is one of the most influential major legal systems in the world, which influenced countries like Australia, USA, Singapore, Southeast Asia, India, Pakistan, Hong Kong, North America, New Zealand, and large part of Africa, and many more. So, as we have seen under the civil law system, now what are the key features or the distinguishing features of the common law tradition? Now, unlike the civil law system, one point we have to remember is, common law tradition has the hierarchical doctrine of precedent. Precedent is a previous decision that is decided by a higher court which becomes binding on the lower courts, where it is going to lay down the ratio decidendi in the case. Therefore, there is a hierarchical doctrine of precedent, and the policy adopted is a case-based system of law. And another distinct feature is there is a centralization of the courts, and one distinct feature of the common law tradition is they have created the prerogative writs. The prerogative writs include writ of mandamus, writ of certiorari, and also the prohibition. And the credit goes to the common law tradition in establishing institutions now such as trust. Now, the concept of a trust is a unique feature of the common law tradition. Similarly, the tort law that is developed by them. Similarly, certain equitable principles, that is specific enforcement of a contract, grant of injunctions as we read today, and where they have given equal importance to the principle of equity. Equity, as you know, is wherever the law is rigid, a higher sanctity is given in the interest of the administration of justice, where principles of equity gained momentum and they are not a supplement, but they are supplanting the existing rules. And another distinct feature we find in the common law tradition, unlike the civil law system, is the pragmatic legal style that is geared to adjudication and the resolution of the disputes. Now, what is this legal style? The legal style is, as it goes to the court, it is decided on the facts of the case, and the ratio decidendi is observed, and accordingly the dispute is going to be resolved. And nextly, we find that there are categories of law and also the separate bodies of law. But one feature we find here is, as in civil law system, common law system does not have a substantive distinction between private law and public law. This is one peculiar feature of the common law system. And one distinguishing feature we find here is, under common law system, is the judicial review. And the English law, however, is not codified like the civil law. Now, in civil law we find right from the 12 tables of Rome, codification was there, Justinian code was there, which was considered as the corpus juris, and the English law has no codified law except under few branches, to name few, that is the commercial law and the company law. English law is not a codified law. Similarly, it has no written constitution also. So, the source of law under the common law system is the previous decision and the law of the European community law. But whereas under the civil law we find it is for them the legislation, and judges cannot be the persons to change the law, but judges are the person to adopt the law that is laid down in the codes that have been given to them. And when we make a comparison, as we have already dealt, so every legal system need to have a particular legal rule, and this in civil law we find that legal rule is related to the moral ideology, but whereas under the common law the legal rule provides the solution to a given case. And the civil law is divided into public and private law, and no such distinction can be found under the common law. And when we go to the common law, there is the difference between law and equity, but however the principle of equity is unknown to the civil law. So, if we take an example of as to how the system that has been functioning, as I have already stated, it is a peculiar feature that we find that under the civil law system, they have adopted the model of justice system which is inquisitorial in nature. But whereas under the common law system, we find that it is an adversarial system of justice system that is followed. Now, what is the difference between these two? So, the inquisitorial system is more particular about the investigation of the case, and it adopted and followed where the investigation, a rigorous investigation is done by the court itself. But whereas in adversarial system it is not so, as we will be seeing shortly. Now, suppose in the pre-trial process is taking place, there is a pre-trial process that is adopted under the inquisitorial system, which is a part of the process to seek the truth. However, when they want to make a decision, the decision making is going to be limited and the conduct of the trial is in the hands of the court. However, victim has a more recognized role to play in the inquisitorial system. Now, the model of justice system under the adversarial system, the common law system followed the adversarial model, and here when an offense takes place, it is the responsibility to gather evidence is on the parties. The police have to gather, the defense has to provide it for them, and that is the defense trial is the exclusive forum for determining the truth by allowing the defense. But whereas in inquisitorial system, we find that it is at the initiation either by the prosecutor or the judge, magistrate sitting, the magistrate who is looking into it is empowered to investigate, make a rigorous investigation of the case. Now, this is one glaring distinction we find in the inquisitorial as well as adversarial system. Now, the second part, as we have already discussed, is the decision making is in the hands of the parties. To go to the court, to hand over the case in the court is in the hands of the parties, unlike the inquisitorial system. And the thirdly, the court's role is confined only to look into the evidence that is given, and it cannot go beyond that. However, the victim has no recognized status in the adversarial system. So, one model of justice system, as we have seen after discussing the civil law system and the common law system, we find that understanding the legal systems and having a comparative idea over the legal systems that are existing is of utmost importance in the study of jurisprudence. The reason, as we have already focused, is to have a harmonized view of the legal systems, to have a better international understanding over it, and have a better knowledge of the other legal systems will have an impact on the reforms to be brought at the national level. So, in this aspect, the legal systems as a comparative study is essential to the student of law. Thank you.